Hello, bonjour. Welcome, everybody. My name is Eric Chaput, Business Advisor here at the World Trade Center, Winnipeg. I would like to begin today's webinar with our land acknowledgement. We acknowledge that we are gathered on the lands in Treaty 1 territory, and the Manitoba is located on the traditional and ancestral lands of the Anishinaabe, Anishinaabe, Innu, Denisalune, and Dakota Oyate nations. We acknowledge we are also on the homelands of the Red River Métis, and that northern Manitoba includes lands that were and are ancestral lands of the Inuit. The World Trade Center Winnipeg team respects the treaties that were made on these territories and acknowledge the harms and mistakes of the past and present throughout our nation. Thank you for joining our webinar, Navigating Your Privacy Obligation as a Business, which will be presented by Del Dig from TDS Law. Before we begin, I want to share a few housekeeping items. Please send all your webinar questions directly to the chat box at the top of your screen, and Del will try to answer as many questions as they can at the end of the presentation. For all logistical questions, please send them directly to the chat box and I will answer your question as soon as possible. And you will also receive a PDF copy of the recording of this presentation within the next week. Okay, let's start this webinar. I would like to introduce you to Del Dick, also goes by the name Kendall. Del is a proud Métis person from the Red River Settlement and an associate at TDS. Her legal practice focuses on privacy and data protection law, wills and estate planning, and Aboriginal laws. As a member of Thompson Dorfman, Sweetman Privacy and Data Protection Practice Group, Dell advises clients on access to information requests, anti-spam compliance, and privacy matters. She also has an extensive experience in estate planning, including drafting wills, powers of attorney, and healthcare directives with special interest in assisting Indigenous clients. Dell's passion for Aboriginal law is deeply rooted in her Métis heritage, and she is dedicated to bring Indigenous perspective to this field. She has worked on Indian status claims, engaged with First Nations and Métis communities on resource development projects, and researched constitutional issues like the division of powers. Welcome, Del, and let's begin this webinar.
Hi, thank you for having me. My practice sounds so random when people describe it. I do have some pretty different practice areas, I'll say. I guess the privacy, technology, intellectual property kind of work that I do and love and I'm very passionate about. And then the other half being the estate planning administration. They're very, very different areas of law, but it's helpful for me to have very different areas of law to think about sometimes, and both of which I try very hard to use to assist Indigenous communities. So I guess I'll jump right in. I'm not the greatest at timing things, so I don't actually know if this presentation will take the full hour or if I'll have to speed up or slow down, but we'll see how it goes. So as mentioned, legal name Kendall Dick, everybody calls me Del. I'm an associate at TDS. I've always been at TDS. I summered here, I articled here. When I got called to the bar, I joined as an associate. I've been here for, I mean, if you count from the beginning, that's 2017, but I've been practicing law. I'm a 5th year associate now. So jump right in. Land acknowledgement was already done, but you know, I always like to include this slide and comment on the importance of land acknowledgements. You see them more and more often now, and it's really wonderful because they are really a method of education, of bringing people's attention to something that they might not have been aware of before. And as a Métis person, particularly important to me. Typical legal disclaimer, but I wanted to add a specific privacy law disclaimer, because privacy law is really in a state of flux around the world right now. There's all sorts of new laws being introduced and old laws being amended. So, what the law is today might be different next year, especially in Canada, as we have Bill C-27, which is meant to repeal and replace the privacy and data protection sections of PIPEDA, and it's being studied in committee right now. So it still has to do the third reading in the Senate, but in theory, it should pass soon and it will update things. This is me. I don't have anything else to say about that. This is what we'll try to cover today. So, privacy and data protection laws in Canada, there's a few of them. There's some that are specific to the private sector, others to the public sector. We'll talk about PIPEDA specifically. PIPEDA is the federal private sector legislation that applies across Canada. If you own a business, it's likely what's going to be most important to you. And then I'll touch a bit on Canada's anti-spam law. So, broad overview of privacy and access laws in Canada. And I promise this will be a very short constitutional law lesson. Because Canada is a federation with the constitutional division of powers, we have privacy legislation at both federal and provincial levels. So PIPEDA is grounded in Section 91, Sub 2, which is why its application is limited to personal information that's collected, used, and disclosed in the course of a commercial transaction, or the personal information of employees for federal works, undertakings, or businesses. They have no authority to regulate provincial employees or nonprofits broadly. They really have to stick to what occurs, employees in federal works and businesses and undertakings, and then what occurs in the course of a commercial transaction. This is also why some provinces have passed legislation that's substantially similar to PIPEDA. So you'll see Alberta has passed a law, BC has passed a law, Quebec has passed a law. Quebec has recently updated their law, so it's a lot stronger now as well. These provinces, so in Manitoba, we don't have a law that's substantially similar to PIPEDA, which means that provincial employees are kind of in a statutory vacuum. Their privacy law applying to provincial employees is really, it's common law. In Alberta and BC, they have this legislation that applies to information collected in the course of commercial transactions, but also to provincial employees. So yeah, these all provinces have the option to enact substantially similar legislation. If they do, then the information that's collected, used, and disclosed within the province is subject to that law rather than PIPEDA. If it crosses jurisdictional boundaries, then it's subject to both. Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador, they've also adopted substantially similar legislation regarding collection, use, and disclosure of personal health information. Manitoba has an ombudsman, but their office investigates complaints under our provincial public sector laws. So the Freedom of Information Protection Privacy Act, the Personal Health Information Act, those apply to public bodies and doctors, healthcare providers. We won't really get into public sector today, but the same principles that run through PIPEDA really run through all privacy laws. There's also tort laws. In Manitoba, we have the Privacy Act, which establishes the tort of invasion of privacy. There are also common law torts, which means they stem from decisions made from judges. We won't get into them today. There isn't really time, but they exist. So, baseline question, what is personal information? can be kind of a deceptively simple question. Generally, it's information about an identifiable individual. There are obvious examples that are sometimes included in laws, but also things like your opinion about someone else, which can be both your personal information and their personal information, because technically it's about both of you. PIPEDA doesn't give specific examples. The definition is just information about an identifiable individual. FIPPA lists specific examples. They all kind of boil down to the same general idea. The word identifiable is the interesting part of the definition. So consider the difference between identified and identifiable. So a statement like Dell has a yellow house is clearly personal information because the individual is identified. But even a statement like the female privacy lawyer at TDS has a yellow house is my personal information because although I'm not, on the face of it identified, I'm the only woman at TDS that practices in privacy law. So because you can Google TDS law, pull up our website, pull up our privacy and data protection section and see that I'm the only woman at TDS that practices in privacy law, I'm identifiable, and therefore it's my personal information. So these are really simple examples, but the concept can get pretty complicated. There are a couple other terms in the data protection field that people can get confused about because they can be used inconsistently, so it is confusing. But I'm talking about de-identification and anonymization. So I think the best understanding now is that de-identification is the removal of identifying markers in personal information, but there's still the possibility of re-identifying them. Anonymization is either irreversible and permanent modification of personal information to ensure that no individual can be identified either directly or indirectly by any means if you use the definition proposed in Bill C-27. Or if you're a bit more realistic about it, then its data is anonymized if at all times reasonably foreseeable in the circumstance, it's irreversibly no longer going to allow the person to be identified directly or indirectly. That's the Quebec definition. So key there is the phrase that it's reasonably foreseeable in the circumstances. There's really a debate about what the definition should be because there's a debate about whether it is currently actually possible to say that it's irreversible, permanently modified, never going to be able to re-identify the person. As more and more data is collected about people, as technology gets stronger and stronger, it becomes easier and easier to re-identify information that was previously de-identified or thought anonymized. So consider aggregated data as well. Organizations like to think that aggregated data is by definition no longer personal information, but that isn't always true because of this concept of identified versus identifiable. So whether individuals in the aggregated data set could be identified depends on the particular group that makes up the source of the data set. The smaller the group, the easier it is to work out who the individual is. If you have aggregated data about individuals in Canada, that's a very, very broad group of people. If you have an aggregated data set about individuals who reside on Peguis First Nation, that's a much, much smaller group and would be significantly easier to kind of work through what might relate to certain people. Personal information can be sensitive or not sensitive. So certain categories of information are going to be considered more sensitive than others. European laws define this explicitly in the General Data Protection Regulation. PIPEDA doesn't, but the Privacy Commissioner of Canada, who's responsible for overseeing PIPEDA, has issued some guidance that confirms certain categories. So it's generally accepted that information about your health, your finances, your political opinions, your sexual orientation are always going to be considered sensitive. Information that wouldn't usually be considered sensitive could become so depending on the context. So the app or the example on the screen is having a particular app on your phone. Having an app on your phone is not
Great.
Oh. Okay. So having an app on your phone is not, immediately sensitive information, but if it happened to be her, which is a lesbian dating app, then suddenly it is, because it's pretty specific information about your sexual orientation can be inferred from that. Location data can also be sensitive depending on how specific it is. So sometimes organizations will collect location data to confirm that you're within the particular province. So, gambling sites, you have to be within Manitoba. Or if you watch Jays games, if you're going to participate in the 50-50, you have to be within Ontario. If you go to Bombers games and you want to buy a 50-50 ticket, you have to confirm that you're within Manitoba. So that's very general location data, but you can also get really, really specific. You can get specific GPS coordinates. That can become really sensitive. Tim Hortons got in trouble for this because they were tracking the precise location of their app users every few minutes, regardless of whether the app was open or not on that individual's phone. So with that data, they could infer a lot about people's lives, including sexual orientation, religion. If you track my movements every few minutes all day long, you'll be able to infer where I live, because that tends to be where I sleep at night. You'll be able to infer where I work, because I usually go there every day. If I go to gay bars on Friday and Saturday nights, you'll be able to infer that. If I go to a specific church every Sunday, you'll be able to infer what my religion is. So it can become really, really sensitive. Biometric data is also very sensitive because it's things like your fingerprints or, scans of your face, like facial maps. So it's sensitive because these things are generally pretty hard to change. So once that information is collected, it's not something that you can change about yourself. So PIPEDA. What is PIPEDA? I've already kind of said this, but PIPEDA applies to personal information that's collected in the course of a commercial transaction, and it applies to personal information about an employee or a potential employee of federal works, undertakings, or businesses. Commercial activity, the definition in PIPEDA isn't particularly enlightening. It just means any particular transaction, act, or conduct, or any regular course of conduct of a commercial character. There was a case, so obviously things where, you ask for personal information while somebody's giving you money for a product or service, very clearly commercial transaction. There was a court case where the federal court was asked to consider whether the personal information that Google collects and creates when you use their free search engine is governed by PIPEDA, which required the court to determine whether using the search engine was considered a commercial transaction. So when I plug something into Google's search engine, I don't have to give them money to get results. But the court took a broader approach than just whether the individual hands over money. They looked at Google's business model and concluded that it was really structured around ad revenue that they earn because people use the search engine. So although these individuals might not be paying Google directly for the service, it is how Google makes money, and Google is incredibly profitable. So the court concluded that the personal information collected by Google through that search engine is subject to PIPEDA. PIPEDA is written a bit oddly in terms of how laws in Canada are usually written. The 10 fair information principles that we'll talk about form a schedule to the Act. And then within the Act itself, there are more obligations and also exceptions to the principles that are in the schedule. Bill C-27 will change that structure. It's still the same principles are going to apply. It's still based on these fair information principles, but they're just going to be incorporated into the Act itself rather than being in this schedule where they're written with, the language is not, it's a bit different from how laws are usually written. So there's been some interpretative difficulties at times. But PIPEDA itself recognizes two fundamental points. 1, individuals have a right to privacy with respect to their personal information, and 2, organizations need to collect, use, and disclose personal information for appropriate purposes. So PIPEDA is really about balancing these two needs. This concept of appropriate purposes acts as a threshold for whether organizations can collect, use, and disclose personal information for the purpose that they've identified. Section 5 sub 3 of PIPEDA says that the purpose for collecting personal information has to be one that a reasonable person would consider appropriate in the circumstances. In addition, you have to get consent, except in very limited circumstances. And we'll talk about consent later, but it's important to know that consent won't save you if the purpose doesn't pass this appropriate purpose threshold. So even if an individual gives you consent to this very specific purpose, if it's not one that passes the appropriate purpose test, you'll be in breach of PIPEDA. There are some specific no-go zones where the privacy commissioner has already said, in these circumstances, very clearly not ever going to be an appropriate purpose. So things like where, the purpose is otherwise illegal, or things like requiring social media passwords for employee screening. Those are always going to be inappropriate. You can find these on the Privacy Commissioner's website. They have a guidance on inappropriate data practices. I think I linked to it. I did, yeah. They have a lot of guidance documents on their website. Because they're in an ombudsman role, they're very helpful. So there's tons and tons of resources on the website to help you understand the different concepts. If you're ever curious or wandering around, they're very easy to read. They're drafted to be easy to read and understand to help businesses. If your purpose is not included in those no-go zones, then there's 5 factors you have to consider to evaluate whether the purpose is appropriate or not. These include the degree of sensitivity of the personal information at issue, whether the purpose represents a legitimate need of the business or a bona fide business interest, whether the collection, use, or disclosure of that personal information would be effective in meeting that need, whether there are less invasive means of achieving the same ends at comparable costs with comparable benefits, and whether the loss of privacy for the individual is proportional to the benefits to the organization. So it's all about balancing. And again, if the purpose is appropriate, even if the purpose is appropriate, you still need consent unless one of the limited exceptions applies. So these are the fair information principles. There are a set of 10 principles that come from a national standard called the CSA Model Code for the Protection of Personal Information. It was developed by the Canadian Standards Association in 1996. It was developed from 8 principles regarding data usage, collection, and privacy, published by the Organization for Economic Cooperation and Development, in case you're, nerdy about weird little bits of history. These principles make up the basis for PIPEDA, for private sector federal legislation. They're included in its schedule, but these concepts they flow throughout all data protection legislation. So accountability is the first principle. For all of these slides, I've pulled some language from the schedule, but there's more. I didn't just kind of reproduce them. So for accountability, organizations have to appoint someone to be the privacy officer. And it doesn't have to be called privacy officer. That word isn't used in PIPEDA, but you have to appoint one person to be kind of the lead. Whatever you call them is whatever you call them. Lots of places are calling them privacy officer now. This person can delegate, but there needs to be one particular individual that's accountable for compliance under PIPEDA. This is the person that access requests and complaints would be directed to. Organizations are responsible for the personal information in their possession or custody, even if you've transferred it to a third party to store or otherwise process it on your behalf. You're still responsible for protecting that personal information and for how it's used. So using a third-party service for processing, like using Amazon Web Services for cloud storage, it doesn't absolve organizations of their responsibilities under PIPEDA. Organizations are still considered to be in control of and responsible for that personal information, and they have an obligation to use contracts or other means to provide a comparable level of protection while that personal information is with third parties. So in terms of any, the terms of any contract that you have with a third party are really important, especially if they say that that third party can use that personal information for their own purposes. If, you're looking at a cloud service provider and the contract says that whatever data you give them, they're able to publish on the internet for everyone to see, you're giving them the ability to disclose personal information that you're in control of. You would need to get the individual's consent to be able to give them that right. So yeah, it's important to review those contracts, make sure that you have whatever they're asking you to agree to, because you won't always necessarily be able to negotiate these. You have the consent to be able to agree to those. Otherwise, you're putting yourself in a position where you're breaching PIPEDA. You should also take a look at, like when you're considering a vendor, take a look at what they have in terms of policies and procedures in place to ensure that personal information is properly safeguarded, including things like training for staff and effective security measures. If they're telling you that they store all the data you give them on somebody's laptop and they never lock the laptop and everybody's access to the laptop, that's, not great safeguarding. Identifying purposes, principle number 2. So you have to tell a person whose personal information you're collecting why you're doing so. Usually at the time of collection, but definitely at least before the personal information is used for the purpose. And that distinction acknowledges that an organization might collect personal information for one purpose and then want to use it for another purpose later on. So if it's already been collected, you can't advise them of that second purpose at the time of collection, obviously, but you can and must advise them of the second purpose before you actually use it, before you actually use the personal information for that second purpose. Identifying and documenting purposes for which you're collecting personal information helps you narrow down what you actually need to collect and helps prevent you from over collecting. So if you sit down and think about what's the purpose here? What do I need personal information for? And you go through the process of writing it down and thinking about it, you can identify what you actually need, what's not actually necessary, what's just maybe a want versus a need, and what's not necessary at all, so you shouldn't collect it at all. And distinguishing between a want and a need is important, and comes up in the next slide. Consent. Consent is really the backbone of our privacy law. It's the backbone of PIPEDA. It's a notice and consent regime. So the knowledge and consent of an individual are required for collection, use, or disclosure of personal information, except where it would be inappropriate. There are exceptions where you don't need consent, but they're very limited. And you can't require individuals as a condition of service to consent to a secondary purpose. So this is where the distinction between need and want becomes important. So for example, if somebody's purchasing something from you, you can require them to consent to your collecting their credit card information, their billing address, maybe their shipping address if it's something that's delivered. And if they won't provide that, then you can refuse them service. But you can't require them to consent to your collecting a bunch of other personal information about them in order to use that information for targeted advertising, for example. You don't need to market to them further in order to provide them with the product or service that they've purchased. So that would be a secondary purpose, and you can't require that they consent to it as a condition of service. There are 2 types of consent. There's express consent and implied consent. For express consent, individuals have to take a positive step, either written or oral, to signify that they consent. So they need to be told the purpose of the collection of the personal information, how it's going to be used, and who it might be disclosed to. They have to understand the consequences of the collection, the use, the disclosure, and they have to take some action. It can be, if you're entering a business premises and they're saying, I don't know, I'm trying to think of a business that does this. But if they, record and take pictures and they ask you to sign a release that says they can take your picture and post your picture on the website, that's an express consent because you're looking at this form, you're signing it where it says you agree that they can do this. You've taken some positive action to signify consent. Implied consent is something that can be reasonably inferred through action or inaction. So, you tell somebody, if you come onto the premises, your image may be recorded by our CCTV cameras because we've put them up for security purposes. If you don't want this to happen, you shouldn't come in. If they come in anyway, you can infer implied consent from that. When you're determining the kind of consent that you need for a specific purpose, you have to consider whether the individual would reasonably expect that their personal information would be used or disclosed for the proposed purpose. You have to consider whether the information is sensitive, like health or financial information, and just generally the overall context. Express consent is best. Generally, where the information is sensitive, you should get express consent. Implied consent is generally only appropriate where information is less sensitive and, the purposes are they're very obvious. They would reasonably expect you to do that. So I think the example in PIPEDA is like renewing a magazine subscription. Although now, see, it's out of date. It's past in like 2001. So we're talking about magazines. But if you subscribe to a magazine, then it's not going to surprise you if in a year you get a notice saying your subscription is running out. Do you want to renew? Well, they've used your personal information because they've used your address and your name to ask you if you want to renew, but that's not shocking. That's kind of in the normal course of things. I would expect a magazine to ask if I want to renew. I might be kind of annoyed if they didn't and I forgot, and then suddenly I don't get the magazine that I like anymore. You wouldn't really expect them to go sell all of your personal information to a bunch of third parties in another jurisdiction, which then starts to market to you. That would surprise you and probably annoy you. Individuals can withdraw consent at any time, subject to legal and contractual restrictions, but if they're withdrawing consent, you have to tell them what the consequences are going to be. So if it means that you can't provide them with a service anymore, you have to explain that to them. Honestly, I'm not sure what contractual restrictions would validly prevent someone from withdrawing consent. I haven't seen an example of that, but the OPC has also said that you can't contract out of your right to withdraw consent. So I'm not sure what's going to fit under that category, but legal restrictions would be something like where you have a legal obligation to keep personal information for a certain period of time. Once someone's withdrawn their consent, you should destroy or anonymize their personal information unless you have a legal obligation to keep it for a certain period of time. But if you don't, and they no longer consent, then you no longer have any reason for keeping the personal information. You don't have a purpose that it's there for. So minimizing retention means you should get rid of that information if there's nothing else that you need it for. And remember, even where you have consent, purpose has to be one that a reasonable person would consider appropriate. So consent also has to be valid. What makes consent valid? Section 6.1 of PIPEDA says that consent is only valid if it's reasonable to expect the individual understands the nature, purpose, and consequences of the collection, use, or disclosure to which they are consenting. So you need to provide specific information about what you're collecting, why you're collecting it, and what the consequences of your collecting, using, and disclosing it might be. So for example, PIPEDA doesn't restrict organizations from transferring personal information across borders and storing it in the US, for example. But if you do that, you have to tell individuals that you do that, and you have to explain what the risks are. So in that case, personal information will be subject to the laws of the jurisdiction that it's stored in. That means different laws surround when and how the government can access that information. And in the US specifically, it's the USA Patriot Act, PISA 702. And Canada has their own laws that allow the government to search your information, access your personal information. But the protections are trickier. So in Canada, the charter will apply to government searches, and you can challenge that under the charter. If personal information is stored in the US, then the Canadian charter is not going to apply to the US government searches of their data. And the US Constitution doesn't offer Canadian citizens protection against those searches. So it's consequences like that you have to give people information about in order to help them make a meaningful decision and validly consent, because consent has to be meaningful. So again, Privacy Commissioner has tons of resources on their website, and they have a guidance document about how you can obtain meaningful consent. So things you have to do include being transparent about what you're collecting, identifying the purpose for the personal information that you're collecting. Consent processes should be easily accessible, user-friendly. So, plain language, creative solutions, links to a more, like doing a layered approach. You'll see on websites, there's lots of websites that have these, very long and detailed privacy policies, and that's important because you need to give everybody information in one place so that it's easy to find, but those can also become really, cumbersome and difficult to get through. So one way to make that a little bit more user-friendly, and user-friendly is really the key here. One way to make that user-friendly is doing like a layered notice where you give a short blurb about, and you just kind of hit the key points of what's collected, why it's collected, who it could be disclosed to, any risks that it might pose. And then you link to the larger policy. You say, if you want more information about this, find our privacy policy here, and you link to that, and they can go looking for more information. I've seen privacy policies on websites where, it's structured as collapsible headings. So they'll have a heading of, what do we collect, and there's a little blurb that kind of summarizes it, but you can click and it expands to more detailed information. So it's allowing people to control how much information they get at a certain time. Consent should be an ongoing kind of process. It doesn't just end the first time you get consent. You have to think about things from your customer's perspective. So you would want to be kept up to date on how your personal information is being handled. You should obtain fresh consent when you're making significant changes to your privacy practices, including, of course, if you're going to use the personal information for a new purpose, and reminding individuals about the consent choices they have of those they've made and those that are available to them. So sometimes you'll get like updates from, I think I get them from Google, for like a Gmail account or something. And maybe Facebook or something will remind you every once in a while that, hey, these are your options for setting your privacy settings. Do you want to run through them again? So that's what they're doing there. They're reminding you about the choices that you've made and those that are available to you as part of keeping consent dynamic and ongoing. Limiting collection. Sorry, trying to keep an eye on time. So you should only collect what's actually necessary to achieve the purpose that you've identified. That applies to both the type of information that you collect and how much you collect. So that was one of the problems for Tim Hortons. They were collecting the precise GPS location of the app users every few minutes, which is both way too specific and way too often. They did not need so much extremely detailed personal information for the purposes that they had identified. There's also a requirement that personal information be collected by fair and lawful means. So that's intended to prevent organizations from collecting information by misleading or deceiving individuals about the purposes. And so things like, you should, there's a temptation to really, really minimize what the risks are or leave them out entirely and really emphasize the positives. You can get in trouble doing that because you don't want to get to a point where you are thought of as misleading or deceiving people, because then the consent will be valid. And you'll be, yeah. Oh, God, what did I do? Limiting collection. Okay, sorry. I pressed a button on my mouse and it went crazy. Principle 5 is limiting use, disclosure, and retention. So you can only use and disclose personal information for the purpose that it was collected for, unless you're required by law to do something else with it. If there's a new purpose identified, you have to get fresh consent. And And personal information can only be retained for as long as is needed to complete the purpose or, meet any legal obligations that you have. So like tax reporting, you might have to keep certain records for, I think, like 6 years after the year it's used for tax recording, and those might include personal information. Organizations cannot keep personal information indefinitely. When it's no longer required to fulfill the purpose that was identified or to fulfill a legal obligation, it should be destroyed, erased, anonymized. Should not keep it indefinitely. A, you can't, you'll get in trouble. B, it becomes dangerous if there's a breach later. Organizations have to develop retention policies, so policies that dictate how long you need to keep personal information. And there's no bright line. There's no period that's going to apply across the board as a minimum. You have to really think about what you're collecting, why you're collecting it, and just the context of your business. So, organizations that where somebody can create an account. And it's Facebook. You create an account. People will sometimes delete their accounts for a period of time and then come back. So in that context, an organization might think about, well, okay, how many people do come back after they delete an account? And on average, how much time passes before they come back? And that can factor into a retention policy. So if somebody's deleted their account, but and they haven't issued a specific, like, please erase my personal information kind of thing, and you know that on average 90% of people are back within 3 months, then your retention policy might say that you keep personal information for a period of 3 or 4 months after an account has been deactivated, because you know that somebody's likely to come back within that period of time. Yeah, I think I covered everything. You might also have like legal or regulatory obligations to keep personal information for a certain period of time. So, doctors have an obligation to keep personal information for a certain period of time. And if you use personal information to make a decision about somebody, then you have to keep that information long enough to allow them access to the information after the decision. If they make an access request, then you have to keep it for a certain period of time after that as well. Accuracy. Personal information has to be sufficiently accurate, complete, up to date, as necessary for the purpose for which it was collected. You really want to minimize the possibility that incorrect information is going to be used, but you also don't want to get on this train of just routinely updating personal information constantly if you don't actually need to do that. So if somebody's purchased something from you and 2 years down the line, I don't know, you're going through and you're thinking you need to update personal information, you reach out and ask them for their credit card number. Like, you don't need to update it at that point. You don't need an updated credit card number because you're not actively processing payments, right? So keep information up to date and accurate as needed, but don't go over it. Safeguards. The information that organizations collect has to be protected by security safeguards that are appropriate to the sensitivity of the information. So if you're collecting, my personal health information, that's sensitive. You're going to need some really robust safeguards in place. If you're collecting, I don't know, my hair color, that's not very sensitive information. So you still need to have safeguards in place, but you're not going to have them as like strong and intense as if it was health information. These safeguards have to protect against loss or theft, unauthorized access, disclosure, copying, unauthorized use, modification, and they can be broken down into kind of 3 categories. So physical measures. So if I have personal information on paper and I'm storing it in a cabinet, then it's locked. Restricted access to offices. Organizational measures. So, security clearances, policies, limiting access to only those who need to know the personal information for the purpose. So, not everybody in your business needs to know a specific piece of information, then not everybody should know it. Only the person that actually needs to know it to complete the purpose should have access to it. Technological measures, so passwords. If you're storing information on a computer, locking your computer with a password, encryption, that kind of thing. And making employees aware of the importance of maintaining confidentiality. So having internal policies in place, training employees on those policies so they're familiar with what their obligations are. Security breaches. So a breach is the loss of or the unauthorized access to or unauthorized disclosure of personal information resulting from a breach of security safeguards or from a failure to establish them at all. Breaches can happen in a number of ways. Hackers getting through your established security measures, disgruntled employees, stealing personal information, the loss of a laptop, and again, failure to establish safeguards. PIPEDA places specific obligations on you. When a breach happens, there's a record-keeping obligation. So for every breach, regardless of the context, you have to keep a record of it for a period of 2 years. And that record has to be produced to the Privacy Commissioner upon request. When personal information is accessed or lost and it presents a real risk of significant harm, then reporting obligations are triggered. So significant harm includes bodily harm, humiliation, damaged reputation, damaged relationships, loss of employment, loss of business, professional opportunities, identity theft, financial loss, those kinds of things. There are factors to consider when you're determining whether it rises to the level of presenting a real risk of significant harm, like the sensitivity of the personal information involved in the breach, and the possibility or the probability that it has been, is being, or will be misused. So if some bad actor hacks into your systems and steals all of your clients', I don't know, financial records, credit cards, addresses, dates of birth, all of these things that can be used to steal identities. And then, they send you an email and say, unless you pay a ransom, they're going to sell the information on the dark web. Well, then very sensitive information has been stolen, and it's been stolen by somebody who has the intention of misusing it. There's going to be a real risk of significant harm there. So if the breach meets that test, then you have to notify the Privacy Commissioner and the impacted individuals. There are specific requirements for the contents of the notice, and the notice has to be given as soon as feasible after the organization determines that a breach has occurred. So there's a ticking clock too. Openness. So this is an obligation for organizations to make readily available to individuals specific information about policies and practices relating to personal information. They have to be able to acquire this information without unreasonable effort. It should be made in a form that's generally understandable. And you could do it in all kinds of ways, whatever makes sense for the nature of your business. It's contextual. Privacy policies that have proliferated on websites are about doing that. But I should say privacy policy is kind of a misnomer. They're better described as a privacy notice because they're about providing specific information. They're really meant to summarize internal policies that you have in place. They're an important part of the accountability principle because they do that. They summarize the internal policies and practices that you have in place that dictate your data handling practices. So the openness principle is it's a driving force behind this proliferation. So it's helping organizations make detailed information about their policies and practices publicly and readily available, all in one place, so it's easy to find. That said, not the be-all end-all. If an organization collects personal information primarily in person and doesn't really operate online, then obviously something else is going to be more appropriate. At the end of the day, individuals need to know how and what you collect, how you're going to handle it, how you're going to store it, what information you're going to share about them. They need to know who is accountable for the organization's privacy compliance and how they can access the information that an organization has about them. So information that should be made available includes name or title of that person, the address where they can be, like contact information where they can be reached, how they can gain access to the personal information that's held about them, description about the kind of personal information it's collected, general account of its use, those kinds of things. We'll go into privacy policies a bit more in a few slides if I can hurry up. Individual access. So, as mentioned, individuals have the right to access their personal information. When they access it, they have the right to challenge its accuracy and completeness. If they think that you have something wrong about them, they have the right to tell you that and tell you what they think what would be accurate. And they have the right to have that information amended as appropriate. If you get an access request, a clock starts, you have to respond within 30 days. You have to provide access at little to no cost. It's generally not appropriate to charge people. And there are, generally the default is everybody gets access, but there are limited exceptions. If one of the exceptions applies, then you have to explain the reason for denial to the individual. So if their personal information is intertwined with somebody else's, you can't separate it. So giving them access would mean that they also get access to somebody else's personal information, and that person doesn't agree to that. Well, there's a whole balancing thing there, but you might have to say, no, sorry, we can't give you access. It would mean that we're disclosing the personal information of a third party, and we're not allowed to do that. Challenging compliance. So if somebody thinks you're not acting appropriately, thinks you're not complying with PIPEDA, they have to be able to address that with you. There has to be somebody that they can forward complaints to or inquiries if they just have questions. The procedure should be easily accessible, should be simple to use, and you should investigate all complaints. If complaints are justified, then you have to take appropriate measures to fix it, including maybe amending your policies or your practices. Privacy notices. Okay. So again, there's no template for these. The OPC won't create a template because they say it's context specific. Your privacy policy, your privacy notice should be specific to your business. Broadly, it should include information to help individuals understand the nature, purpose, consequences of the collection, use, and disclosure. It should be in plain language, or at least use plain language summaries. There should be other user-friendly features built in to make it easier for people to navigate and understand. And it should really be a summary of your internal policies. So the OPC says that organizations should have at least five following internal policies. Policy about collection, use, and disclosure of personal information, which includes requirements for consent and notification. So outlining for employees their obligation to inform individuals of this information and obtain their consent, and their obligation to limit what's collected. A policy about access to and correction of personal information. So outlining for employees the individual's right to access and correct personal information and how employees can help individuals exercise that right. Knowing which processes to follow, including the timelines that are required. Policies about retention and disposal of personal information. So outlining the obligation not to retain personal information when it's no longer required, outlining how long it's meant to be kept in an organization and how it can be safely disposed of. Obligations about responsible use of information and information technology, including the security controls and safeguards that we talked about. So outlining the obligation to make reasonable security arrangements. The fact that what's reasonable depends on the sensitivity of the information, who should have access to it, and policies about challenging compliance. So about the individual's right to make a complaint or inquire, what the process is for that, who they're going to connect with, what that person's going to do. Other things to consider in your kind of public-facing notice are scope, outlining what it applies to. Is it just the website? Is it the organization as a whole? Is it just an app? Types of information collected, the purpose and use, retention periods, safeguards you're going to use, who it might be disclosed to, any risks associated with giving you this information about how an individual can access the personal information, and information about consent, an explanation of their choices for consent and how to exercise them. And then contact information for the person that they can reach out to for more information or to make complaints. For meaningful consent, things you should really emphasize are what's being collected, who it'll be shared with, the purpose, and any risk of harm. When you're doing layered notices, those are the things you really focus on. I also include information about consent and withdrawing consent there because I think it's really important for people to know. Privacy policies can be tricky because, it's important to include all of the information in one place because you don't want to make people jump around looking for all of this information because it can be confusing, it can be inconvenient. But of course, that means that privacy policies become very long and can be hard to read. So you really have to think creatively about ways to balance this and in ways that make sense for your particular business. Because one solution isn't going to fit every single business. Otherwise, we'd all be doing it already. So consider options for making it user-friendly. Just think about when you're trying to read a privacy policy, what's annoying you and how would you fix it? Even if your organization doesn't collect any personal information, it's still a good idea to have something on your website that emphasizes that fact, because collecting personal information is so ubiquitous today that if a customer sees a website without a privacy policy, they're not going to assume that it's because you don't collect personal information. They're just going to assume that it's because you're not being transparent, or you don't understand your obligations, or you don't care about your obligations. And trust and reputation are difficult to build and easy to lose, even where the loss isn't justified. So organization or users shouldn't have to guess as to what your practices are. There are lots of resources and information on the OPC's website, and it's meant to be very easy to read and understand. So strongly suggest you go there. I'm at 1 o'clock, so I feel like I have to stop even though I didn't get to Castle. Is that correct?
You can wrap up. Del, you can finish up, and then we'll open up for question at the end.
Okay. Well, I'll just be very brief about Castle. It applies to when you're sending commercial electronic messages, among other things. So commercial electronic messages, marketing messages, where you're trying to encourage somebody to, use your business, buy something from you. And you need consent to send those. It has to be express or implied. Implied comes in specific ways. It's laid out in Castle what counts as giving you implied consent, when you can rely on that. But generally, it's why you see when you're purchasing something a separate little empty checkbox that says, I want to sign up for newsletters. And it's empty specifically because that is how you get express consent. And if you go on I think the CRTC website has, it's same idea as the Privacy Commissioner's website. They have lots of resources that you can poke through to help you understand your obligations under Castle. One thing I'll say to wrap up, because I always get this question, but sending an email or some kind of electronic message to ask for consent to send electronic messages isn't in and of itself an electronic message that you would need consent for. So you can't just email everybody and say, can I send you marketing messages? Do you want to sign up for that? That itself would be considered a commercial electronic message under Castle that you need consent for first. And that's where I'll leave it. Jump through
Awesome.
to the last.
Okay, perfect. Well, thanks, Del. That was lots of information. So yeah, we're gonna open up for questions. So if you have any question, you can either insert it in the chat or unmute. I know we are a little bit over time, so if you have to go, I do want to respect your time. But yeah, if anybody has any questions.
I do have a question while we wait for others. to ask. Um, would implied consent would be like someone attending this webinar and having their name as their descriptor, and us seeing that would be implied consent, that they consent that their name is visible?
Yeah, I mean, if you're giving them, like, implied consent also depends on people understanding. So,
Hmm.
when I join these things, I understand that my name is going to be there and whatever I put is going to be visible to everybody that's on the call. And by joining, I'm therefore consenting to that. Um, so yeah, that would be an example of implied consent.
Thank you.
We have a question from James. Thanks for the presentation. What precaution do I need to apply when using Scott's directory to discover prospective client and send letters or make cold phone calls?
Scott's directory is not a thing I'm familiar with. What is Scott's directory? Now I'm Googling. I'm not doing it very well.
James, you can also unmute and elaborate on that.
Scott's Canadian Business Directory. So this is business information, or like contact information for businesses. So this is going to be probably more of a Castle question. Because if it's business information, like PIPEDA includes an exception for business information if it's, like the fact that my email address and phone number and name and title are on the TDS website. If you're using that to contact me about my business, then it's, it falls within that business exemption, that business information exemption. For Castle, like, and you can, yeah, it's really tight. Like if you're sending messages about things that are unrelated, so sometimes I get emails about, you know, paving driveways as a service that's really, really not related to my job as a lawyer. So it starts to come under this is a marketing message that I would need consent for under Castle. I haven't given that consent. There's no implied consent there. But yeah, it's really about what the information is, what you're reaching out to them for, whether there are any kind of disclaimers beside their information on a website or a directory that says they don't want to receive messages. I would say go look at the CRTC website. They have a lot of resources there that will help you figure out the specifics. And if you still have questions, then you should talk to a lawyer. Talk to a lawyer about your specifics.
Okay. We also have a question from Bonnie. We have employees who wants their pay stub left for them in an unsecure spot. I have had them sign that this is what they want and no, it is not secure. Is that sufficient?
I mean, employee privacy falls in a weird void. So I'm assuming you're a provincial business, so it's not going to be part of PIPEDA. I can't think of what's on a pay stub right now. Generally, it's just a pay stub. It's not like it's the actual check. Like generally, I'd be trying to avoid that at all costs, because if there's information that's on there, it's lost. Once it's lost, it's out there. There's no stopping that. So yes, having them sign something to acknowledge that it's, left in this spot, it's not secure. These are the risks. It offers you some protection, but I wouldn't be doing that if I could avoid it at all costs, I would say.
Okay. Do we have any other question, guys? Oh, she says, I do, LOL. Okay. So I just put in the chat a few upcoming webinars and events. So we have on Thursday, June 20th, a webinar called Doing Business in the USA for Manitoba Companies. So definitely tune into that one. And then we also have on Wednesday, June 26th, our WTC talk featuring sibling Andréan Dandeneau and Christian Dandeneau. So again, please check that out and looking forward to seeing you guys there. Del, thank you for this presentation. Lots of information. I'm sure I'm going to get lots of emails after today's session that, I need the slides and the recordings. So again, thank you, and I wish everybody a good day.